Hello everyone, my name is Nicholas Taylor, and I'd like to welcome you to this pre-recorded presentation for the 2023 IIPC Web Archiving Conference on the topic of better evidentiary standards for web archives beyond the commonly but uncritically accepted Internet Archive Standard Legal Affidavit. As you're all likely keenly aware, the best effort nature of web archiving and the bias of Wayback-like replay engines towards completeness of representation over temporal coherence means that any rendered archived web page can't necessarily be taken at face value. The magnitude of temporal discrepancies is sometimes so significant that the replayed web page turns out to be demonstrably inauthentic. This can be neatly illustrated with the now infamous example from Ainsworth et al.'s 2015 research paper, the 9 December 2004 capture of the Weather Underground forecast webpage for Varina, Iowa. To make this clearer, I've isolated and highlighted the area of interest, which includes the local time, date and time that the forecast was last updated, location and elevation of the observation, temperature, precipitation, and radar image. The discrepancy is readily apparent. The infographic and precipitation description indicate rain, but the radar is totally clear. We click through on the overlay banner link for About This Capture. And we're presented with the list of web resources that make up the page, sorted by those that were archived least to most recently, that is to say, a summary view of the web page's degree of temporal coherence. The 4 top resources that were archived the furthest in time from the web page are 4 images. 2 were archived more than 9 years after the web page was archived. The other 2 were archived more than a year and more than 9 months later than when the web page was archived. On closer inspection, it turns out that it was the radar graphic that was archived 9 months after the root web page. The takeaway is that the facts supported by any given archive web page may not be self-evident, and while most archive web pages won't militate against their authenticity quite so conspicuously, the impact of temporal violations may be no less material to their evidentiary use and value. If the temporal dynamics of the archived web page replayed in the Wayback Machine weren't opaque enough, consider that it's likely to enter the case record in litigation as a PDF. Then the temporal span of embedded resources can no longer even be examined, and it will be all too easy to suppose that what is being proffered is in fact a screenshot of a historical web page rather than a Frankenstein's monster temporal composite. So why does this matter, and what does it have to do with the evidentiary use of the Wayback Machine or web archives? The key questions and outcomes of legal cases may depend on the date times of the embedded mementos specifically, for example, copyrighted images or graphic trademarks. Temporally incoherent web pages raise doubts about their authenticity and therefore their ability to attest to certain facts. As it stands, Wayback Machine evidence, the most frequently used web archive in litigation, doesn't come in for as much scrutiny as it probably deserves. However, the incidence and observation of discrepancies such as the previous example may ultimately undermine confidence in the reliability of web archives for evidentiary use to a greater extent than is deserved. Why is Wayback Machine evidence subject to less scrutiny than it deserves? Mostly it's because legal professionals, including both attorneys and judges, don't understand the affordances and limitations of web archives. The preoccupation with authentication and admissibility is foregrounded with much less attention dedicated to interpretation. This is exacerbated by courts' ready acceptance of the Internet Archive Affidavit as a mechanism for securing the admission of basically any content from the Wayback Machine. The lack of substantive evaluation of case-specific Wayback Machine evidence is a flawed approach. It means that in many instances, Wayback Machine evidence will continue to be admitted without scrutiny, but by chance it should have been admitted. In other instances, probative Wayback Machine evidence won't be admitted, even though it should be, on account of general misperceptions of web archive reliability or unfortunate choices of authentication strategy. Notwithstanding occasional examples, such as the temporally incoherent weather web page, I do think that Wayback Machine evidence should generally be admitted and treated as authentic. It's just that that shouldn't happen without some evaluation of whether specific evidence supports the facts that it purports to. This seems to be consistent with the Internet Archive's guidance on interpretation of web pages accessed through the Wayback Machine for evidentiary purposes. as a one-off indicator of the status quo in which the Internet Archive's familiarity and reputation supersede any content-specific analysis of the evidence, in 2020 there was a case in the U.S. District Court in the Southern District of California in which a party sought to have admitted web archives produced by a records management-focused web archiving company by analogizing those archives to the Wayback Machine. The judge denied admission of the evidence, expressing skepticism with the comparison, as the Internet Archive offered a free, publicly available service, whereas the company offered a paid service in anticipation of litigation. Okay, so we're overdue to take a closer look at the Internet Archive affidavit itself. I'll do so shortly after briefly reviewing the other strategies employed to authenticate and secure admission of Wayback Machine evidence, at least in the US context. The Wayback Machine is referenced in the dockets for at least 300 US federal court cases. Notwithstanding the frequency of its use, Wayback Machine evidence faces a higher bar for authentication than other websites. Strategies for overcoming these concerns and securing the admission of Wayback Machine evidence include judicial notice, the Internet Archive affidavit, testimony of a witness with personal knowledge of the web content, testimony of an expert witness, and mutual stipulation by parties to the proceeding. I'll discuss these in greater depth in the section ahead. Wayback Machine evidence has commonly been a subject of judicial notice. Rule 201 of the Federal Rules of Evidence provides for judicial discretion in the admission of evidence whose authority or veracity is so well established as to not be subject to reasonable dispute. Where a court is favorably disposed towards judicial notice of Wayback Machine evidence, this is by far the most efficient mechanism for its admission. However, there are material differences in the receptivity of various jurisdictions, if not judges within those jurisdictions, that are determinative of the success of this approach. All else being equal, judicial notice is also more likely where the opposing party hasn't made any specific assertions as to the unreliability of the presented evidence. Rule 901(b)(1) of the Federal Rules of Evidence provides for the authentication of evidence through the testimony of a witness with personal knowledge that the evidence is what it is claimed to be. This commonly works to authenticate evidence with a witness with personal knowledge of the historical content of a web page or website accessed through the Wayback Machine. However, testimony by a non-expert witness accessing historical web content of which they have no specific knowledge doesn't typically succeed. Rule 702 of the Federal Rules of Evidence provides for the authentication of evidence by means of expert witness testimony. Such testimony must be given by an expert with specialized knowledge, be based on sufficient facts or data, be the product of reliable methods, and reflect reliable application of those methods by the expert to the facts of the case. Expert witnesses have tended to be a reliable way to authenticate Wayback Machine evidence, even as they are less used and require more overhead than, say, judicial notice or the Internet Archive affidavit. An expert witness makes the most sense where the Wayback Machine evidence requires more interpretation, explanation, or qualification. Lastly, we come to the Internet Archive affidavit. With the indication of one or more web addresses, payment, and appropriate lead time, the Internet Archive will provide a standard legal affidavit that attests that the indicated pages are authentic representations of Wayback Machine contents. The affidavit is a reliable and efficient mechanism for authenticating Wayback Machine evidence. At least from a review of US federal cases, I'm unaware of any instance where Wayback Machine evidence was denied admission with a caveat, correctly applied affidavit. The affidavit works best when all of the information necessary to support the assertions is unambiguously present on the archive web pages. It should not be expected to work as neatly in instances where some amount of interpretation or inference is required, or reliability is a more conspicuous concern. Okay, let's review in a little more detail Internet Archive's guidance on the affidavit and what it does and doesn't attest to. The Internet Archive provides affidavit FAQs. A couple of key excerpts. First, they recommend relying on either judicial notice or stipulation as more streamlined mechanisms for the authentication of Wayback Machine evidence. This is sensible advice, but as I mentioned previously in the discussion of judicial notice, doesn't work as reliably. Second, the affidavit only affirms that the associated screenshots are authentic copies of records from the Wayback Machine. The Internet Archive provides no interpretation of those records nor makes any claims about when the archive web content was available, other than providing the capture dates. The Internet Archive has also posted example language from the affidavit itself. Let's walk through a few key excerpts. The Internet Archive makes clear that the Wayback Machine favors temporal proximity. The content linked from any given archive web page will be the version of that memento that is closest in time to the capture date time of the outlinking web page. The Wayback Machine is responsible for replay of archived web content. As we know, the content is primarily archived using other software. Each file that is captured has its own distinct date and time of archiving. It follows from the last point that the individual assets that make up a given archive web page or website may or may not have been captured around the same time. As we observed with the initial example, the capture dates may be staggered by considerable lengths of time. Lastly, the affidavit only affirms that the given screenshots reflect nothing more or less than authentic copies of content stored in the Wayback Machine. No interpretation of or further assertions regarding the proffered information is provided. And this is the key point. The Internet Archive can readily provide for the authentication of web pages from the Wayback Machine by truthfully affirming that provided screenshots authentically represent what the Wayback Machine presents, while disclaiming that that should necessarily be taken as an authentic representation of the historical web page on that capture date, and courts will currently invariably accept that as evidence. For the cases where web archive evidence may not come from the Internet Archive, or the evidence shouldn't otherwise be taken at face value, we would do well to promote less institutionally specific criteria or mechanisms for the determination of whether that evidence in the web archive from which it is sourced are trustworthy. What I'm fundamentally talking about is evidentiary best practice for web archives. I have some ideas to share on this front, but I want to start by reviewing what criteria and practices seem to be suggested by extant frameworks. To the best of my knowledge, no judicial entity has put forth explicit guidance. Treatment of Wayback Machine evidence isn't consistent across jurisdictions. There otherwise isn't a clear framework that we can infer from judicial precedents. Other than that, the Internet Archive affidavit is almost unfailingly accepted, and we've already discussed why that's problematic. The Sedona Conference, a community of legal industry practitioners with expertise in electronically stored information, published guidance on the evidentiary use of the Wayback Machine as recently as 2020. It's an explicit framework, but the quality of the guidance is mixed. It gets some aspects right. The Internet Archive affidavit works reliably for the authentication and admission of Wayback Machine evidence, for better or worse. Some of it could be better. It suggests, for example, that judicial notice of Wayback Machine evidence is relatively uncommon, and the fact of archive files being stored in WARC plays a major role in addressing authentication issues. And then some of the guidance is questionable or outright wrong. Technologies for web capture and replay are conflated. It is claimed that it's possible to delete or change archived information. It is noted curiously and without further elaboration that the Wayback Machine is, quote, not accepted as a forensic evidence collection method, end quote, notwithstanding its by now frequent and familiar use in many legal proceedings. It is stated that the Wayback Machine provides for, quote, an identical replica of the website, end quote, which for a variety of reasons it mostly does not do. So on balance, I don't think we can presently be looking to the Sedona Conference community for the best set of best practices. I also reviewed the service marketing copy of commercial companies engaged in records management and litigation-oriented web archiving. There was a lot to like there in terms of desirable elements for web archive evidentiary best practice, such as archive web resources accompanied by captured timestamps and metadata, system hooks facilitating archiving of published web resources in near real time, completeness and fidelity of captured enabled via browser-based capture, web archives being securely stored on the vendor's servers and abstracted from any live web dependencies, and evidence submitted for inclusion in a legal proceeding accompanied by affidavits and/or expert testimony. I think that evidentiary standards for web archives could still be better, though. In this last section, I'll offer some suggestions of additional factors that could or should be taken into account. What makes web archives trustworthy, serving their ability to be used in an evidentiary capacity? I divide this into two broad categories: capabilities and practices that are already largely in place in the web archiving field, and areas of potential investment to address gaps or otherwise bolster trustworthiness. Starting off with aspects of web archiving as currently practiced supporting trustworthiness, it helps that individual web resources are archived atomically. As long as we have to contend with temporal incoherence, it is vital to be able to understand the distinct provenance of individual files. Capturing a web page's constituent files also allows for a higher fidelity and interactive representation of that web page in a way that a screenshot doesn't. Typical web archiving practice involves not just the capture of web resources themselves, but also the incidental HTTP headers, the conversation between the capture agents and the web resource hosts. These can function as indicia of authenticity, supply metadata that may be relevant to facts of the case, as well as supplement timestamping efforts. A fundamental attribute of archive web resources is that they are timestamped according to when they were captured. They are therefore fundamentally situated in both place and time. The temporal dimensions of live web content may matter no less for its evidentiary use, but are often not as readily or authoritatively discernible. All else being equal, an institutional imprimatur supports the trustworthiness of web archives. This seems fine to me, even in the case of the Internet Archive Affidavit, as long as it doesn't obviate the necessary content-specific analysis. Most web archiving is carried out by academic, cultural heritage, and governmental organizations that are invested in the integrity and persistence of information, but that have no particular stake in the use of their archives in litigation, which is good. There are many other organizations no less trustworthy than the Internet Archive engaged in web archiving, whose archives would deserve no lesser presumption of authenticity. The possibility of being able to audit open source web archiving tools weighs in favor of the trustworthiness of the web archives that they generate and to which they provide access. To the extent that there will invariably be differences between a live site and an archived version, it may be easier to understand the reasons for the variance with open source tools. Where community information standards and file formats are employed, designed as they are to facilitate digital preservation, that increases the trustworthiness of the resulting web archives. Okay, so now we're transitioning to reviewing shortcomings and current capabilities where we could conceivably make improvements to bolster the trustworthiness of web archives for evidentiary use. As I highlighted at the beginning of the presentation, temporal coherence is likely the single most significant concern here. There are some services that assist in visualizing the temporal spread of a given composite memento, but they are very much point solutions, and no existing services that I'm aware of go further to allow for visualization of temporally violative elements per se, or toggling their visibility. Browser-based crawling could prospectively reduce the incidence of temporal coherence, but it seems unlikely that it will be able to scale to address the issue for the majority of web archives that may ultimately be used for evidentiary purposes. Turbin et al. Have documented that hashing the same composite mementos replayed from the Wayback Machine over a period of time not infrequently yields different checksums. While likely still down the road, it's conceivable that an enterprising trial attorney looking to challenge web archive evidence could raise the question of why the Wayback Machine apparently doesn't conform to digital forensics best practice for fixity. Possibilities for mitigating and/or qualifying this issue include robustification of our infrastructures, improved transparency for why mementos are inconsistently delivered, and new or extended API endpoints that could deliver an encapsulated web bundle. Even better, that web bundle could be cryptographically signed, verifiably attributed to the organization that created the archive. This would move web archives more towards the best practices for forensics on other types of digital information. Lastly, it would be great if we didn't have to rely in the main on what inferences we could draw from only one web archive. Being able to consult comparable mementos from multiple web archives would raise confidence and help to compensate for missing resources or temporally heterogeneous composites. Here I'm talking not just about redundancy, that is, identical copies accessible from multiple sources, but also about independence, diverse organizations hosting independent web archives that have been separately created using diverse technical stacks. The idea isn't that independent archives should show the same results, it is that results should corroborate one another. So, where does that leave us? I don't want to overstate the case that all of this is immediately necessary or likely to be taken on board by legal professionals. That said, as social media and web-based collaboration platforms in particular become increasingly mainstream concerns for electronic discovery and litigation, litigators will become more sophisticated also about the qualifications on web archive evidence. As those with a deep understanding of web archives, we would do well to be ready to promote what we suppose makes them trustworthy. With that, I thank you for tuning in for this pre-recorded presentation, and I hope that it has been informative and thought-provoking. A copy of these slides can be found on my website, noelhandel.org. I look forward to the forthcoming discussion session. Thanks.